Advocacy at the Scalabrini Centre in Cape Town. She joins us now from our Cape Town studio. Good evening and welcome to the Full View. Let's start off here. I see the Business Insider has quoted you as saying that what government is basically doing is building a paper wall.
Yes, that's correct. These new regulations do nothing to improve the efficiency or effectiveness of the asylum system. Instead, they increase the barriers that asylum seekers are going to face when trying to claim asylum in South Africa.
Do you think it's on the basis that the premise may just be that some of the asylum seekers and some of the refugees in the country are in the country illegally, and that's the reason why government is coming up with such processes that some have even argued are quite cumbersome?
Look, these new regulations need to be viewed in terms of framed in terms of three broad issues. The first is the specific vulnerability of refugees, and this has been recognized by our courts. The second is South Africa's obligations in terms of its constitution, our Bill of Rights, and international law. And the third is the historic challenges that the refugee system in South Africa has faced, which has been major backlogs, long queues, and what seems like major difficulties on the part of the Home Affairs to implement the refugee laws in our country.
Mm-hmm. What do you think government's response should have been, rather than including, for instance, what's now expected of foreign nationals, and these are asylum seekers as well as refugees, that they are not supposed to be part of any political activity? Also take into consideration that the reason that some of these people find themselves here is that because they've run away from the government of the day, wherever they come from.
Yeah, so one of the concerns with this clause, and there are many clauses in these new regulations that are concerning, but this political activity clause seems to undermine rights that are established in our constitution. Mm-hmm. For example, freedom of thought, freedom of association, etc. There are other provisions in these regulations that are very concerning. So, for example, there are major changes that have been made to the refugee application process. There are changes that could undermine the ability of refugees and asylum seekers to work and study in South Africa. There are also a number of exclusion provisions, as well as provisions allowing the state to withdraw refugee or asylum status in South Africa. And then there are also changes to the appeal system. While doing all of this, what Home Affairs has also done is they've removed most of the provisions that were in the previous regulations that allowed for some type of accountability towards the officials at Home Affairs. So, for example, the previous regulations set a 180-day time period for the adjudication process to happen in. Often that was not complied with by the department, but now that time period has been removed entirely. There is no time period in these new regulations. Mm-hmm.
Let's quickly touch on this particular issue, and this is some of the complaints that have come through as well, is that if you look at, for instance, the Henry Oka case, and in that particular matter there is a conviction, under this particular new law, does that then give the minister the power to send him back to Nigeria?
So we need to think about, so I heard you mention that these are new immigration regulations. They're not. They're refugee regulations. Mm-hmm. There's an international protection standard that the South African government is supposed to comply with for refugees. These are persons of concern that have been deemed under both international law and South African law to be in need of the South African government's protection. Mm-hmm. So it doesn't mean just anyone from any country would be able to use the refugee laws in South Africa. It is specifically people that are deemed to be in need of protection for either for reasons of being persecuted in their home country, or because they've fled grave disturbances to the public order in either whole or part of their country, or they're family members of a recognized refugee here in South Africa.
Sure. And do these new regulations give us an indication of how, for instance, the government or the minister can determine whether somebody is a threat to national security? And I ask this on the basis of this turf battle between Rwanda as well as South Africa, where you had Paul Kagame, who had accused the country before of harboring terrorists.
The regulations are, they don't say much about national security. What I would say is that these regulations do seem to be a step towards the securitization of migration in general. And we see this type of narrative not only in these regulations, but also in conversations around the Border Management Authority, for example. So it's not just when we think about Trump's America or Boris Johnson and Brexit that we think about the building of walls and the stifling of migration and the opportunities that it brings. But South Africa is certainly not far behind both of those countries in terms of securitization of migration and undermining our refugee protection system.
Let's just quickly touch on this particular one, and this is something that always comes up when there are protest actions, specifically in townships, where some people are saying that foreign nationals are taking our jobs. We heard that the Minister of Small Business said that government would be responding with some sort of legislation. Does this new legislation at all include limitations in certain industries where companies operating in those industries are not allowed to employ refugees or even foreign nationals?
So previously, the way that refugees and asylum seekers were able to be employed in South Africa was the right to work and to study was won in a court case brought by a woman called Mrs. Wachanuka. And what the court said there is that an individual's right to be productive in society and to engage in a productive effort, such as work, is intricately linked to our right to dignity. And so to deny an asylum seeker the right to work impacts or undermines the right to dignity. That's what the status quo has been since that case. The case also said that Home Affairs' Standing Committee for Refugee Affairs would be allowed to say whether asylum seekers could or could not work. And up until now, there's been a general provision on an asylum seeker permit that says asylum seekers have the right to work and study. And that was the result of the Wachanuka case. These regulations may have the effect of undermining that. And that would then have the knock-on effect of potentially undermining the right to dignity. So what these regulations say is that certain employment sectors may be reserved for South African citizens only, not for asylum seekers and refugees, but that would have to be announced by the Department of Home Affairs in collaboration with the other departments, the other respective departments.
Sally, just quickly in closing, will you be challenging any parts or clauses of this new legislation in court?
So Scalabrini Centre is an NGO. We try and assist asylum seekers. We believe in the opportunity of migration and what it brings. And we're certainly going to be looking at these regulations very closely and trying very hard to engage with the department even further. We did make comments on the regulations when they were first published for comment, which was 29th of June 2018. The department only gave 13 business days for civil society to make comments, and there was heavy criticism by civil society for that. The department hasn't responded to that criticism or allowed any further engagements, which we see as a very worrying trend. And so we will be looking at them closely, and we will be assessing which rights they impact, and if there is a serious undermining of our constitutional values and Bill of Rights, it's certainly something we would consider.
Well, thank you so much, Sally Gander, who is the head of advocacy at the Scalabrini Centre.